The moment my brother smirked at me across the boardroom table, in front of his lawyer, his accountant, and the estate trustee, I felt something shift in my chest, not hurt, not anger. Something quieter than both of those, something that had been waiting a long time to finally be still. She's always needed someone to take care of her, he said, not even looking at me when he said it, talking about me like I wasn't sitting 4 feet away. That's just the reality of the situation. The estate trustee, a careful woman named Ms. Okafor, glanced at me over the rim of her reading glasses. I said nothing. I folded my hands on the table and waited. That moment, right there, is where this story ends. But to understand why I was so calm, you have to go back almost 20 years. You have to go back to a girl who believed, with her whole heart, that her family was the safest place in the world. My brother is 6 years older than me. Growing up, I thought he was the coolest person alive. He drove a beat-up Honda Civic that smelled like pine air freshener and hockey tape, and he'd let me ride shotgun on the weekends when he drove to the rink in Barrie. I'd watch him on the ice and think, that's my brother. That's mine. Our dad worked in logistics, long-distance hauling mostly. He was gone 3-4 nights a week. Our mom held everything together with the kind of quiet competence that never got acknowledged because it was just expected of her. She packed lunches, attended school meetings, drove me to figure skating on Tuesday mornings at 6 a.m. without ever once complaining. Our dad had inherited a property from his own father, a house and 3 acres of land outside of Collingwood, Ontario. It wasn't a farm exactly. More like a large lot with a century-old house that needed constant upkeep, a shed, a sugar maple stand, and a view of the escarpment that made your chest open up every single autumn. We called it the property. It was never just called land. It was the property, with a weight to the word that meant legacy. Dad always said the property would be handled equally. You're both my kids, he'd say, end of conversation. He died when I was 23, a cardiac event. Quick, the doctor said, which was supposed to be a comfort. My brother was 29 and already working in commercial real estate in Toronto. The will was read 6 weeks after the funeral. I drove up from Guelph, where I was finishing a graduate certificate in financial planning. I remember the drive, the 400 North, the gray November sky, Tim Hortons in Barrie, hands tight on the wheel. What the will said was not what I expected. My dad had left the property to my brother to manage, with a note that said my brother would act as executor and primary decision-maker on behalf of the family estate, with proceeds to be distributed at his discretion upon sale or development of the property. At his discretion. I remember reading that phrase 3 times. My brother put a hand on my shoulder and said, "I'll take care of everything, don't worry about it." His voice had a new quality in it that I hadn't heard before, something slightly elevated, a half step above where it used to be. I drove home to Guelph in the dark, and I didn't cry until I got inside and took off my coat. For 2 years, I told myself it was fine. My brother was handling it. He knew what he was doing. He was the older one, the one with the business background, the one who had always understood money better than I did. Or so I believed, because that was what everyone had always told me. I finished my certificate. I got a job with a financial planning firm in Waterloo. I was good at it, methodical, calm under pressure, good at reading long documents for the things that weren't said as much as the things that were. My clients liked me because I didn't oversell and I didn't panic. I called my brother every few weeks. He always had a reason why things hadn't moved forward on the property. The market timing wasn't right. He was having it assessed. He was looking at a potential development partner. There was a heritage designation issue. He'd been busy. I asked twice very directly whether I could see the current financial statements on the estate account. He said he'd send them. He never did. The 3rd time I asked, he laughed. Not meanly, exactly, just the way someone laughs when they think the other person doesn't quite understand how things work. "You've got your career thing going," he said. "I've got this. That's the deal. That's the deal." Like we'd agreed on something, like there had been a conversation I hadn't been present for. I hung up and sat at my kitchen table for a long time. Outside it was raining, that specific October rain that feels like it's been falling since 1987. I made a list. Then I made a second list. Then I called a lawyer. Her name was Harriet Caulfield, and she had an office on King Street in Kitchener. And she was exactly the kind of person you want on your side when someone has decided, quietly and without announcement, that you don't exist. I brought everything I had. The will, the email chain, my notes from phone calls. Harriet read through it all with a pen in her hand, making small marks in the margins. "The language here is broad," she said, "but it's not unlimited. You're a named beneficiary. He can't simply exclude you from the estate accounting. That's not discretion, that's a breach of fiduciary duty. She told me my options. I could request a formal accounting from the estate through the court. I could file a complaint with the Ontario Superior Court of Justice, Estates Division, if my brother refused to comply. These were not fast processes, they were not cheap processes, but they were real processes with teeth. He's going to say you're being difficult, Harriet told me, not unkindly. He's going to say a lot of things, I said. She looked at me for a moment. You seem very calm for someone in your position. I'm a financial planner, I said. I read the fine print for a living. I sent my brother a formal letter through Harriet's office in November. It requested a full estate accounting, all transactions, all expenses, all income generated from or related to the Collingwood property, including any lease agreements, sale negotiations, or development discussions from the date of our father's death to present. He called me 40 minutes after it was delivered. "What is this?" he said. His voice had dropped back down several octaves. All the elevation was gone. "It's a formal request," I said. "It's standard procedure. You're going to make this a whole thing. I'm asking for an accounting of my father's estate," I said. "That's not making it a thing. That's asking for what I'm entitled to by law. You have no idea how much work I've put into this." "Then the accounting will show that," I said. "Send it, and we're done." Silence. "I need time," he said finally. "You have 30 days, I said. Harriet set that out in the letter." He hung up. He did not send the accounting. What happened instead was a call from his lawyer, a man from a downtown Toronto firm whose first move was to question my mental state. Not directly, he couched it in concern. He told Harriet that my brother was worried about me, that I had been erratic since our father's passing, that he believed I was acting under some emotional distress that was affecting my judgment. I was sitting across from Harriet when she relayed this to me. I watched her face carefully. "He's doing what people do when they don't have a legal argument," she said. "He's trying to make the problem you. Can he do that?" "He can try," she said. "It won't work. You're a licensed financial professional. You've held your registration without incident for 4 years. There's nothing to support that characterization." I nodded, but I'd be lying if I said it didn't land somewhere. It did, not because I believed it, but because I recognized it. That move, the way it worked, the way it was designed to make you question your own footing. I went home that night and I did not sleep well. But I got up in the morning. I went to work. I helped a couple in their 60s restructure their retirement plan after a late career job loss. I was steady and specific, and I gave them a clear picture of where they stood and what they could do about it. I was very good at my job, and I had not forgotten that. The estate matter went to court 8 months later. My brother had provided a partial accounting, full of gaps, missing documentation, and 3 years of unexplained management fees paid to a numbered company that Harriet traced back very quickly to a holding company my brother had set up 6 months after our father's death. He had been paying himself to manage the estate. Not a reasonable management fee, not something disclosed or agreed upon. He had drafted his own paperwork, run it through his own numbered company, and drawn a salary from our father's estate for 3 years without ever telling me it was happening. The number was not small. The Ontario Superior Court, Estates Division, is not a dramatic place. It is a room with good acoustic tile and very clear lighting, and a judge who has seen everything and radiates the particulations of someone who has heard every version of every family argument that has ever existed. The Honorable Justice Beaumont was a man in his mid-60s with reading glasses on a chain, and the economy of movement of someone who never wasted energy on anything. My brother sat across the aisle in a suit that cost more than my monthly rent. His Toronto lawyer sat beside him, and I watched them lean together and murmur, and I thought about all the phone calls. The reassurances. That's the deal. Harriet sat beside me. She'd been up since 5. I knew because she'd emailed me at 5:17 with 3 attachments. When Justice Beaumont reviewed the numbered company documentation, he was very quiet for a long moment. Then he said, "Counsel, can you help me understand the basis on which your client believed he was entitled to draw management compensation from the estate without disclosure to the co-beneficiary or approval from the court?" My brother's lawyer stood. He offered an explanation about industry standard practice, about the reasonable expectation of compensation for estate administration, about the complexity of the Collingwood property. Justice Beaumont listened with the expression of someone waiting for the answer to a different question. "Was this disclosed to your client's sister?" he asked. Silence. "Was it court-approved?" More silence. Then, said Justice Beaumont, and he let that word sit in the room for a moment, we appear to have a problem. I looked at my hands. I did not look at my brother. I didn't need to. What came out over the next 2 days of proceedings was not just the management fees. There had been a buyer, a developer from Barrie who had approached my brother 18 months after our father's death with an offer for the Collingwood property. A serious offer, a strong number, well above assessed value. My brother had declined it without consulting me. He had instead entered into a private arrangement to lease the property to the same developer for a fraction of that value, with an option to purchase built in at a below-market price 3 years down the line. The lease payments had been going into the estate account, technically, but then being drawn out again in management fees. When Harriet laid all of this out, document by document, the courtroom was very quiet. Even the court reporter seemed to slow down. My brother's lawyer asked for a recess. During the recess, I stood in the hallway and drank a bottle of water and looked at the window at the end of the corridor. Outside was a parking lot, and beyond it, a strip of gray November sky. The same sky as that drive to Barrie the day the will was read, the same November, a different woman standing in it. When we went back in, my brother looked at me for the first time that day. Really looked at me. I didn't look away. I just waited. Justice Beaumont's decision came 3 weeks later, in writing. My brother was found to have breached his fiduciary duty as estate executor. The undisclosed management fees were to be repaid to the estate in full, with interest calculated from the date of each withdrawal. The below-market development arrangement was voided. The estate was to be wound up under the supervision of a court-appointed trustee, and the proceeds divided according to the original terms of the will, which, properly interpreted under Ontario estate law, entitled me to an equal share. There were also costs awarded. My brother had to pay my legal fees. I won't pretend it felt like a movie moment. It didn't. It felt like relief, which is a quieter and more complicated thing than triumph. Relief has a physical quality, a loosening in the shoulders, a return of full breath. I sat in Harriet's car in the parking garage afterward, and she had classical music playing low on the radio, and neither of us said anything for a full minute. "You did that," she said finally. "We did that," I said. She shook her head. "You came in with every document. You knew exactly what you were looking at. A lot of people in your position wouldn't have caught it, or wouldn't have known what to do with it once they did." I thought about my dad, about the will, about at his discretion. I thought about whether he'd known what would happen, or whether he'd just never thought it through, the way people don't think things through when they trust the wrong person to be the right person. I decided it didn't matter. Not anymore. The property sold the following spring. The court-appointed trustee handled the listing, a real estate agent out of Collingwood who knew the area, knew the value, and sold it in 11 days to a family from Mississauga who were looking for a place to bring their kids on weekends. I drove up to see it one last time before closing. The maple stand was just starting to come in. The house looked the same as it always had, a little tired, a little patient, like it had been waiting for someone to notice it again. I stood on the porch for a while and looked at the escarpment. I thought about my dad driving up here on a Saturday morning in the truck, coffee in the console, radio on. I thought about the way he used to say, "This'll be yours someday," in a voice that made it sound simple. Nothing is simple, but some things are worth the fight. My brother and I don't speak. That's not a dramatic statement. It's just a fact, like a weather report. I didn't cut him off with a pronouncement. I didn't send a letter. I just stopped reaching out, and he stopped reaching out, and the silence settled in the way silence does, when there's nothing left to say that hasn't already been said in a courtroom. Some people ask me if I'm sad about it. I think about that question carefully every time it comes up. And the honest answer is, I'm sad about the version of him I thought existed. The guy in the Civic Pine air freshener letting me ride shotgun. That guy I miss. The man who sat across the boardroom table and talked about me like I wasn't there. Him I don't miss at all. My share of the estate settled in late summer. It was the largest single deposit I had ever seen in my own bank account. I sat with it for a few weeks before I did anything, partly because that's good financial practice, and partly because I needed to make sure I was making decisions from a clear place and not from the particular giddiness that comes with a long fight finally ending. I used part of it to pay down my mortgage. I'd bought a small semi-detached in Kitchener 2 years earlier, on my own, without asking anyone for help. I used another part to set up a small investment account that I'm not touching for 15 years. and I donated a portion to a legal aid organization in Ontario that helps people navigate estate disputes when they can't afford a lawyer. Because I know what it costs. Not just money, though it's that too, but time and energy and the particular kind of courage it takes to keep going when someone you trusted is betting that you won't. Last spring, a client came to me, a woman in her late 40s, just lost her mother, dealing with a brother who was executor of the estate and not being forthcoming about the financials. She sat across from me in my office and she looked tired in a specific way I recognized. The tired of someone who has been told over and over that the simplest questions are somehow unreasonable. I told her that she had rights. I told her the exact questions to ask. I told her to put everything in writing from that point forward, every conversation, every request, every non-answer. And then I gave her Harriet's number. She called me 3 months later. "It's moving forward," she said. "He had to produce the accounting." "Good," I said. "How did you know what to tell me?" I looked out my office window. The maples on the street were starting to turn. That specific Ontario October orange, that means the cold is coming and everything is beautiful precisely because it won't last. Because someone did the same thing to me, I said, and I didn't let it stand.